Okay, this webinar will be focusing on the Layman's Guide to Contract Terms. Please allow me to introduce today's presenter, Jennifer Elmore.
Good afternoon. I hope everyone's doing well today. I want to thank you for coming. Next slide, please. The information provided in this webinar does not and is not intended to constitute legal advice. Instead, all information, content, and materials available are for general informational purposes only and given as a result of Meriwether and Williams' experience working with small and emerging contractors. The webinar is not to be construed as a substitute for review by legal counsel and other professional advisors. It is our recommendation that contractors should have an attorney review all of their contracts. The purpose of this webinar is to give you some insight into your own contracts and how contracts affect your relationship, either with an owner and or a prime contractor. As I said, I want to thank everyone for attending today. We start with tips before you bid. Next, we will review contract language, showing sample contract language. Lastly, we will review a partial checklist of all topics covered today and compiled to help you review your contract. At the end of each contract section, we will pause for a moment, and if I start moving too quickly, I'll pause more to ask to see if there's any questions. Please submit the questions via the Q&A, as Johanna has already stated, and we will do our best to answer your questions. The premise of this seminar is to assist you in understanding your contracts before signing, especially if your company cannot currently engage or retain an attorney. Also, we want to remind you that sometimes it is possible to negotiate not just your bid, but potentially some of the terms and conditions of your contract. Next slide, please. Today's objective is to address contract review to help you assess your risk and avoid pitfalls in construction contracts. As we said, we intend to provide guidelines covering the bidding phase, the actual contract language, and the potential impact of contract provisions on your business. Next slide, please. So this is the part during the bidding phase, and this is something that we ask and hope that you do for each contract you enter into. This is before you even see a contract. Before bidding or entering into your contract, we want you to do your due diligence and understand the reputation of the owner and or prime contractor. As a first step, review the reputation of an owner or prime contractor and their relationship with their subcontractors and or other prime contractors. The contracting community is pretty small, so you can get that information easily. To find out more you can about the owners or prime contractors, you can 1, speak with other small and emerging contractors. 2, Google the prime contractor's name for any litigation or lawsuits that are outstanding. One thing to pay attention to also is to see if the prime contractor has worked in your geographic area, or are they new to the market, which means they're not going to know as much as they should know about the area in which they're serving. Also, just as subcontractors usually must pre-qualify to work with prime contractors, vetting a prime contractor or owner in advance of entering into a relationship with them is important. So the prime contractors shouldn't just pre-qualify you, you should also pre-qualify them. Some of the items you can learn in advance are their payment terms. What is the pay cycle, and do they follow what their contract says? Ask for a blank subcontract agreement in advance so you can review the terms and conditions in the subcontract agreement. If bidding to a public entity, search for contractual boilerplate language online to know the terms and conditions before you think of bidding. Additionally, does a prime contractor have performance and payment bonds? and find out how to file a claim with a prime surety company if they're not paying you in a timely manner. If working directly with government entities, find out the stop notice process for public contracting and mechanics lien process for private contracting and where you can file that in advance. You always need to file your preliminary lien process because it's a procedural thing in order to file your stop notice. Subcontractors' contracts should review plans and site conditions. Reviewing site conditions in advance of bidding for potential variations or conditions that may create necessary changes to your bid proposal. As a subcontractor, make sure that you bid your scope of work. Contractors bidding the same scope of work will have divergent prices. For small and emerging contractors, there is a large cost in running a business, and when working with the larger primes or larger specialty contractors, it becomes necessary that you bid your scope to reflect your actual costs. Are performance and payment bonds required by an owner or prime? What is the price of bonding? You can ask in advance if the price of your bonding is to be included in your bid price, or can you include it as a pass-through cost? Next slide, please. Oh, there's hold on. Before you sign the contract, review the contract. Review your contract to make sure, and this is before you sign it, when you're already low, make sure that the price and scope in the contract matches what you put in your bid proposal scope of work. Confirm that the scope in the agreement matches the scope of work in your bid proposal. Ensure that the agreement accurately states and includes the exclusions from your price proposal. Ensure that the negotiated items are included in the contract before signing. We were recently working with a subcontractor that had negotiated weekly payments from the prime, but the subcontract and exhibits to the subcontract had only the standard monthly payment terms, which means that's what they would have done despite the pre-negotiated weekly terms. If a subcontractor, review prime owner terms and conditions. So this is, if you're a subcontractor and you're working on for a government contract as a subcontractor, you have a right to get the terms and conditions because those flow down into your contract. As we will discuss later in this presentation, subcontract agreements often bind subcontractors to the same terms and conditions that regulate the owner and prime contractors' contracts. Next slide, please. I'm going to take a breath and say, are there any questions? Okay. So I'm going to, so one of the things that's really important in reviewing your contract is the schedule. The schedule becomes a material term of the contract. Is the contract based on, so these are the things you need to look for, and you can just do an Adobe Acrobat, a find and search to get these items. Is the contract based on calendar or business days? Is there an acceleration clause to accommodate delays? And so one of the reasons why we ask these questions is your contract will have a time is of the essence clause. Next slide, please. So time of the essence is another way of saying that the schedule is a material term of the contract, or the schedule is important and the parties to the contract will enforce it. This essentially allows a prime contractor to terminate the contract of a subcontractor if you do not adhere to the schedule. In a subcontract, the general contractor owner will specify a completion date and often include the time is of the essence provision. If the subcontractor does not complete its work on or before that date, the general contractor may choose to terminate the subcontract, hire another subcontractor to complete the job, and sue the original subcontractor for breach of contract. And this here, what you're seeing here is sample contractual language that you'll see in your contract, and it is usually underlined just like that, time is of the essence. Additional questions to ask regarding the schedule is there are often frequent delays on construction contract. Is there an escalation or an acceleration clause in the contract that may be triggered by time delays? If time delays are so great that there is an increase in labor rates and or material costs, does the contract accommodate increases due to delays? Does the contract mention business or calendar days? When it just says days, are they calendar or business? That makes a difference by how long you can respond to a question. Next slide, please. So review the contract, and this is regarding delays. And so what are the procedures for submitting delays? What is the timing for submitting claims for delays? What are the consequences for not submitting the claims in a timely manner? Next slide, please. So this is the standard language that you will see, and each contract will be slightly different. So no damage for delays is what we call a risk allocator clause within the construction industry. This provision explains that while the contractor or subcontractor is not entitled to a claim for delay damages, they might be entitled to an extension of time. When a delay in the schedule is created, contractors have to assess the specific circumstances surrounding the delay, the type of damage, the root cause of the delay, and react accordingly, and follow contractual procedures for notification of the delay. So essentially what we're asking you to do is, if there's a delay that you did not cause or might have caused, that you document it. You make sure to send it off to the contractor, the prime contractor, or the owner of the project to have it documented in the way they specify. Next slide, please. So if the delay rises to litigation, to mitigate the damage for delay clause, the subcontractor contractor must prove that the delay was so long and of such a nature that it would not have been likely outcome conceived of by the parties before entering into the contract. So that the delay was caused by unknown conditions on the project site. That the delay was due to an owner's interference with a contractor subcontractor. The owner showed bad faith in delaying the project. Additionally, delays on the project may trigger an increase in costs, and therefore knowing in advance if there is an escalation or acceleration clause in the contract is a good business practice, especially if the time delays are so great that there is an increase in labor rates and or material costs. Next slide, please. And if there's any questions, Johanna, will you please let me know? Okay.
Yes.
So in this section, we'll be going over okay, we'll be going over next slide, please. Next slide, please. Okay. Back 2 slides, please. Sorry. There, perfect. Okay, sorry about that. So what we're talking about now is what we call waiver of claims, and you often find that in a contract. And what this clause does is allow for waiving of consequential damages or indirect damages. Now I'm going to explain what those are. Consequential damages, otherwise known as special damages, are damages that can be proven to have occurred because of the failure of one party to meet a contractual obligation or a breach of contract. Example of consequential damages are property damage, personal injury, attorney's fees, lost profit, use of space, and loss of reputation or good standing. And the damages have to be foreseeable. One example of consequential damages for an owner might be a loss of rent or income if a building were not opened according to the agreed upon schedule. So if you're painting a restaurant and they can't open according to schedule, then they're going to make a claim for the damages that are lost. The importance of this clause is that a mutual waiver of consequential damages does not stop an owner or contractor from applying liquidated damages to a contract if there is a substantial delay, meaning liquidated damages should replace consequential damages rather than supplement them. Next slide, please. Claims for consequential damages. For consequential damages for prime and subcontractors, you may recover direct costs. It's the consequential or indirect costs that pose a threat to your profitability on the project that may not be recoverable. If the consequential damages are waived, then you should review your contract for liquidated damages that we will be discussing now. So liquidated damages, or LDs, to make it simpler, are damages that are meant as a fair representation of losses in situations where actual damages are difficult to ascertain. So when you can't figure out, if you can't open your restaurant, how much revenue you would have lost for not being able to open the restaurant due to construction delays, then what they would do is put liquidated damages into a contract, and they would just have a guess as to what that might be. So in general, liquidated damages are designed to be fair rather than punitive, even if it doesn't feel that way. They change depending on the size and subject importance of the project. Liquidated damages are designated before contract inception and represent actual damages though difficult and impossible to prove. And just as a reminder, one of the items that are tied to liquidated damages are something called flow down provisions, which may impact LDs in your contract, and we'll be discussing them later in this presentation. So next slide, please. So this is the this is actually two contract clauses that we're discussing. We have at the top, you have that bolded, that time is of the essence, and then you have the boilerplate language, and this is for the city and county of San Francisco, which talked about contract time and liquidated damages. And you can see here again, once again, calendar day as opposed to business day, so that they will be assessing damages on a 7-day basis and not on a 5-day basis. So, so in this slide, you can see that, next slide, please. So this is also sample LD contractual language, and here you can see there will be liquidated damages and consequential damages. Additionally, a prime contractor may pass down via the flow down or incorporation by reference provisions, which we'll discuss later, the LDs from the owner agreement to performance and payment bonds. The LDs to the subcontractor. So what that means is that if there's a liquidated damage from a government entity of $100,000, but your contract says only $5,000 per day, then which one prevails? And that's a question you need to ask. And on one of the contracts we worked on, we were assisting a subcontractor to obtain a performance and payment bond of $600,000 to a prime contractor on a $65 million contract. The language in the subcontractor was similar to the language in the slide above. The city of San Francisco's LDs on the project started at $10,000 a day for substantial completion and accelerated to $50,000 a day for final completion on a $600,000 contract. And those were just flowed down to the subcontractor directly. So how we figured we were able to intervene because we thought a $600,000 contract with a 10% profit would have lost all their profit within 6 days of delay if they'd been passed down the $50,000 a day for final completion. The subcontractor surety would not issue the bond, performance and payment bond, as the prime was passing down the LDs directly to the subcontractor and felt the LDs were onerous or punitive. We worked with the project manager of the city and county of San Francisco and a contract compliance officer on the project. And as a team, we were able to negotiate with the prime to have reasonable LDs passed down to the subcontractor that were acceptable to the surety company so that they were able to bid on the project and complete it successfully. Next slide, please. Okay, so one of the things we'd like you to really think about before you enter and when you look at your contract is we want you to think about the payment schedule. What is the timing for payments? What documents need to accompany the payment application? What is the retention? What does the contract say regarding slow payment or non-payment? Next slide, please. So you can see here that part of that sample progress payment language is every month you should have all your progress payment and final payment to be included on the 20th day of each month. Next slide, please. So, and I know this is pretty small, so I'll read it. So this one requires that you submit your progress payment the 5 days prior to the 25th of each month, which is essentially the 20th. I don't know why they wrote it that way. You also, it tells you how you have to do it and what you need to do in submitting lien releases. And it tells you the retention on the project that it's 95%. So what to review and to keep in mind when you see these things. The progress payment cycle and what documents should accompany the progress payment invoice. Are there any forms required by the owner prime to be submitted? Request from owner prime a sample of the pay application documents if not included in the contract documents. What is the retention that an owner prime has in the contract? Can you negotiate that amount? What is the timing of the payment? If the owner's payments are delayed, how long do you need to wait? Are your payments contingent or a condition on the prime's contractor being paid? What recourses do you have if the prime doesn't pay? On government projects, contract compliance officers or owner's representatives may be able to assist you in expediting progress payments. Some prime contractors have a factoring type system in place to advance progress payments before the prime has been paid by a public entity or a payment processing system in place such as Textura. It is beneficial to know the cost of the system in advance of your bid so that the cost can be included in your bid. So it may be minor, but it does add up. I know that what recourse does a contractor, subcontractor have in the event of a non-payment of progress payments? And then this is something we think is really important and we're willing to discuss with you later. What is the mechanics lien stop notice process in the area in which you're working? Next slide, please. So this is really, we think this is really important. There are two types, the California contingent payment clauses, and there are two types of clauses. There's pay if paid and pay when paid. Now, pay if paid is prohibited in California, but what it actually means is pay if paid clauses are when I, the prime contractor, get paid, then I will pay you if you have completed the work. These clauses are generally unenforceable on private and public projects in California, but for example, they are allowable in Arizona. So pay when paid are allowed in California as long as payment is provided within a reasonable time. So they get paid and they need to pay you, or even if they don't get paid, they need to pay you. The question is, what is a reasonable time? And the unpaid party, you're not getting paid, can file a claim. So, and some examples are on the next slide. Next slide, please. So these are the payment timing clauses. And this is something that anywhere you work, you should always Google this. You can Google payment timing and then whatever public entity. And so for the federal government, it's the Federal Acquisition Act, or FAR, and the Prompt Payment Act is what it's called. On undisputed invoices, not undisputed, is a 45-day payment to primes, and the primes are then required to pay the subcontractors 7 days after. For state of California contracts, the Prompt Payment Act on undisputed invoices is 45 days to pay the primes with payment, and with subcontractors being paid 10 days after. The city and county of San Francisco, it's called the Prompt Payment Program. Also undisputed invoices, it's 30 days to prime with payment to subcontractors 3 days after. For the county of Alameda, it's called prompt payment. On indisputed invoices, it's 30 days to primes with subcontractors allegedly getting their payments 10 days after. For city of Oakland, it's called the prompt payment policy. On undisputed invoice with 20 days to primes with payments to subcontractors 20 days after. So you should know the payment terms for the public entities where you will be working as a prime or subcontractor. If working as a prime, then this should be reflected in your contract. If you are a subcontractor, then check the prime's contract for discrepancies and discuss with the prime in advance. Prompt payment information may be Googled again with the name of the public entity and the words prompt payment. And this does not apply to commercial contracts. So we do recommend that you look at this for your contract, because oftentimes your contract may say something different than what is allowable, and you should just bring this to the prime's notice. Next slide, please. So before you sign the contract, all of this, review the contract. And one of the things we want you to think about are change orders and claims. What are the timing requirements? What can be included in the change order pricing? What are the allowable markups? What happens if you do not submit timely? Next slide, please. So we have once again bolded. So in this one, there is no notice to the sureties if you have a bond, and you have 7 days to respond with a detailed price calculation. So one of the things this shows you in this sample language is how, what are the timing requirements? You've got 7 days if there's a change in the work. And as we always say, change orders should be approved in writing where possible, especially on a field change order. Next slide, please. So this one shows you total markup, the lesser of 10%. This one tells you what you're allowed to mark up: administrative expenses, general, overhead, supervision, profit, and how much. So this allows you to know in this language what can be included in the change order pricing, what are the allowable markups. So what happens if you don't submit in a timely? Have you waived your right to the change order? And oftentimes, if you don't submit it within the allowable amount of time, then you are not entitled to that work necessarily. So always get it in writing. Always make sure that you submit it within the time frame that they say. And if you have a bond in place, if the prime contractor doesn't notify the surety, let your surety broker know that the price has increased, to make sure your bond is covered and covering you. Because at a certain time, 20% increase over the price is considered a material change to the contract. Also, if you please note that we have a business recovery series on Meriwether and Williams YouTube channel that is entirely devoted to change orders. For more information on how important that is, for you to look at. And so for example, and oftentimes, and this is something you can Google again, when you're looking at the boilerplate language from public entities, because they're usually online and accessible, that public entities often have codified allowable markups in their contract. So for example, the city and county of San Francisco changed extra work, direct cost, markup percentage, contractor direct labor, 35%, contractor direct materials is 15%, contractor direct equipment 15, subcontractor of any tier direct labor 35, subcontractor supplier materials 15, and equipment 15. So for labor, they allow a 35% markup on the city contracts. For equipment and supplies, it's 15%. But if you know this, then you can include that in your change order and markup. If you don't know this, and for example, there's a contradiction on a subcontract terms that says only 10%, then you need to find out or negotiate with the prime before you sign the contract to make sure you get the allowable markups for your work. Next slide, please. So one of the provisions that could be in your contract that we want you to take a look at is the protection of work. And essentially the protection of work is a risk mitigation for the prime contractor and owner, allocating the liability protection of subcontractors' work product to subcontractor. So what they're doing is they're shifting liability from themselves onto you. And then the sample contract language here. And so in this slide, you see that, or in this language, it says that the protection of the work for the condition until final acceptance of the work by architect, owner, and contractor. And I didn't bold it, and I apologize. It's the second. But why this is important is this protects the prime contractor and owner while a subcontractor is completing their portion on a project. So these clauses usually require that a subcontractor fix anything that goes wrong with the portion of work until the project is completed. But let's say you're the painter let's say you're the painter. And for example, you've gone in and you were only to paint the lobby. And then you went in and you were out within 2 weeks. And you were still, according to this, you were still on the hook for protecting your project and your work afterwards. So you want to make sure that you're only protecting your work and not more than that. There's a question, I believe. Let me see if I can. Okay. So if you have, and why this is really important is if you have a multi-year project and your scope of work is only a section of the multi-year project, then depending on the type of work or trade and the risk of your work getting damaged when you are no longer on site, it could become costly and problematic to protect your work after you're no longer on site. And as I said, if you have any negotiating power, have the prime contractor agree to you protecting your work only while you are actively working on the project, and have the prime contractor sign off on your project when your section is complete, instead of requiring you to protect your work for the entirety of the contract until completion and having to wait for the owner, architect, and contractor sign off. Another way to protect your business is to keep a daily journal of work performed with documented date-stamped pictures. Next slide, please. So the next is hold harmless or indemnification agreements. So just to let you know, indemnification is to indemnify another party, is to compensate that party for loss that that party has incurred or will incur as related to a specified incident. And so you're making hold harmless agreements is you agreeing to make them whole if a loss occurs. Okay, next slide, please. So why this is important is you can see in this contract, as small as it is in this hold harmless language, subcontractors shall defend, indemnify, and save harmless contractor and owner, including their officers, agents, representatives, employees, affiliates, parents, and subsidiaries. Sorry, I can't even say that word today. And so why this is important, and so it's a duty to make any loss, damage, or liability incurred by another. Indemnity has a general meaning of holding one harmless. That is to say that one party holds the other harmless for some loss or damage. As a subcontractor with a limited scope, you should review the indemnity language and attempt to limit whom you indemnify. If you are a subcontractor on a project without a design build scope, then it may not make sense to indemnify the architect, engineer, or similar design professionals. If there are problems with the plans and drawings, you do not want to be required to defend the plans. And this is what we always recommend. Always have your insurance agent, broker review your indemnification and insurance language, because they can then purchase the insurance to make sure you are covered. Next slide, please. So, and that's where we get into the purpose of insurance. The purpose of insurance is to aim to reduce financial uncertainty and make accidental loss manageable. It does this substituting payment of a small known fee, an insurance premium, to a professional insurer in exchange for the assumption of the risk of a larger loss and a promise to pay in the event of such a loss. I'm going to repeat what I said before. Have your insurance agent review the insurance section to ensure that you are adequately covered, both the prime and owner terms if you are a subcontractor and the subcontract insurance requirements. There may be an additional insurance coverage that covers you and not the prime contract and owner. For example, a subcontractor was on a project and his insurance program met the requirements of the owner and the prime contractor, but a review of the contractual insurance requirements did not include builder's risk. Builder's risk in this example would have protected the subcontractor's tools on the project site and materials before installation, as the prime contractor's insurance would not have covered the loss or reimbursed the contractor until the materials had been installed in the building. Next slide, please. Okay, so one of the things before you sign the contract, and this is just for you to know, we want you to know what is the warranty, or what is the contract warranty, what is the warranty period, what is the relationship between the warranty period and the performance and payment bond, and what is the difference between the warranty period versus the manufacturer's warranty. Next slide, please. So here's the language that you will see in a contract, and it's all different, but it's pretty much stays standard for a period of 1 year from the date of final completion. So make sure to review the warranty period in your subcontracts as well as the owner's terms and conditions. If a performance and payment bonds are required, surety companies are uncomfortable with providing surety bonds for small and emerging contractors for projects with a warranty period of more than a year. If the surety company does provide a longer warranty period, this may increase the price of the bond. So we just want you to be aware of this so that you can make sure that you include that increased bond price in your estimate. Also review to ensure that there are no errors in the contract specifications, requesting for a warranty period of the subcontractor instead of the manufacturer's warranty on the product supply installed. Recently, we worked with a subcontractor on a project. The owner specification asked for a 10-year warranty for a specific item, which should have been for the manufacturer's warranty. It was an error in the specifications, and we worked with this contractor to correct the specifications before entering into the contract. Next slide, please. So before you enter into the contract, some things you need to look at are the disputes. How are disputes resolved? Who pays for disputes litigation? Where are disputes litigated? What law governs the dispute? Next slide, please. Sorry. So in this one, you can see it's the rules for construction industry of the American Arbitration Association. Okay, so when you look at how are disputes, does the contract mention, this one mentions arbitration? Is it arbitration or mediation? Is the arbitration or mediation binding? Who pays for the dispute litigation? Who pays for the court costs and attorney fees? Does each party pay for their own fees? Or does the losing party pay for all the fees? Where are disputes litigated? Will the dispute happen close to the project site, or is another location designated as a site for dispute? We were working with a subcontractor on a County of Alameda project. The prime contract documents required that in the event of a dispute, binding arbitration would take place in Colorado. The project was in County of Alameda. The witnesses were in County of Alameda, and there would have been substantial costs for a small contractor to move the litigation to Colorado and pay for it. So that's something that you try to discuss with them in advance. And then what state law governs, because you could have a contractor coming from out of state and having it in, litigation once again in Colorado, and it'd be Colorado law. Okay, next slide, please. So this is the reason why flow down provisions, or it's also called incorporation by reference clauses. A flow down provision or incorporation by reference clause, the definition for these two clauses are similar, and they have a similar effect on the contract documents. A flow down clause is a contract provision by which the parties incorporate the terms of the general contract between the owner and the general contractor into the subcontract agreement. So you can think of it, it flows from the owner of the project down to all subcontractors. Incorporation by reference includes named documents into a contract or subcontract agreement by referring to the documents which become part of your contract. They essentially end up having the same thing, whether it's flowing down or pulling them into the contract. So why this is important? So it's especially important for subcontractors because it impacts your contract. And so next slide, please. So in here are two samples of the language. You would see by reference, all terms and conditions. So the flow down or incorporation by reference clause adds to the subcontract terms, the plan, specification, conditions of the contract, drawings, addenda issued prior to the execution of the agreement between the owner and prime contractor, and all other documents unique to this project. This provision allows the project's owner to impose obligations and restrictions on a subcontractor despite there being no contractual relationship between them. This means a subcontractor is required to know the terms and conditions of the owner prime contractor. Therefore, when signing a subcontract without reviewing the master contract terms and conditions, subcontractors do not always fully know what they're agreeing to. You should ask for a copy of the general contractor's agreement. The prime contractor is allowed and may redact the agreement to hide confidential information, but the prime contractor should be able to provide a copy of the owner's terms and conditions to the subcontract for review. Now, one of the things that you can also do in advance, if you are working with one type of public entity and you're a subcontractor, is you can get their contract boilerplate language so that you know it in advance. So what is passed down and in the contract, the schedule is passed down from the owner to the subcontractor, liquidated damages, the warranty period, the insurance requirements, the indemnification, the payment terms, and the claims requirements. So those are certain areas that we've kind of gone over, but you also need to know. Next slide, please. So this is just a kind of state of California, just so you're aware of. State of California has passed a law recently, and on public projects, retainage is limited to no more than 5% of each progress payment. If they're asking for 10, you can refer them to this law, and it can be reduced after 95% of the work is complete. And so there are some exceptions to this rule. If a contract is extremely complex, they can petition to have a larger, but it's one of the things we wanted to make sure that you guys were aware of. Next slide, please. So this is our suggested contract review checklist. And as soon as we receive your evaluations, we will send out the checklist to you. So does the contract include the correct scope work? Are all inclusions included in the contract? What is the project schedule and how does it affect the contract? What are the notification procedures and timing? And what are the consequences of not adhering to the delay requirements? What are the parameters for time delay? Have consequential damages been waived? What are the LDs for the project? Next slide, please. Are there cost factors associated with the payment process? What is the public entity's timing requirements? What is the mechanics lien stop notice process and procedures? What are the procedural requirements for change orders? What is an allowable inclusion in the change order? When should the surety company be notified of a change order? Who protects the work versus actual project duration? Next. Who are you indemnifying? So that's who are you protecting? Do you have sufficient insurance coverage? What is the warranty period for the contract? Warranty versus manufacturer's warranty period. What is the dispute process? Where would the dispute process be handled? What law governs the dispute process? What is the public works retainage requirements? Next slide, please. So this is what it's not going to look this way, but we just as an overall. So yes, no, not applicable. And next slide, please.